are aware of some of the history that's involved here with this, and so recounting the history or going over what's happened in the past was probably not going to be too productive. So again, let's just limit our comments to whether or not the legal standards have been met to grant a special exception use. Okay. Having said that, we're going to start. Why don't we start with Ms. Bunting, since she
we need to have the applicant come forward if he or she is present.
I apologize. Yeah, you're right.
I'm Dr. Miller Newton. I have been a resident of Madeira Beach since 1981. I reside at 13253 Boca Ciega Avenue, although I lived previously on 3rd Street.
Good evening, Father.
Thank you. And I'm also an Orthodox priest, and I do have a sort of different religious name, Father Kazian Newton, because the Orthodox Church, the Greek and Russian Orthodox Church, require that priests, deacons, and bishops have names of saints, and unfortunately, neither one of my birth names qualified. So, the Christ of the Sea Foundation is a small Orthodox church, religious residence, and retreat center. It has been in existence legally since, I think, about 1987, but the building that became a chapel was constructed in 1998 and was actually dedicated in 1988, and we began to use it then as a community room and private chapel. The city was informed of it because at that time, rumors started in the neighborhood we were building a halfway house, and people got upset. And we had a meeting with the city council and clarified that. So it's not a new thing. It was in existence before several of the people here who object to it moved to the community or acquired property, which I find a little strange that we're being required to do things by community sentiment, but we're not here at the time. At any rate, when the issue first came up and was made by Mr. Kelly and Mrs. Bunning, Mr. Kelly objected to a Christian religious institution in his neighborhood with the symbolism. And I met with the city and pointed out in their record they knew that we had a private chapel, and that there, as a matter of fact, existed 6 or 7 private chapels, to my knowledge, without special exceptions. Turns out there are many more. Every Roman Catholic convent associated with a Roman Catholic school has a chapel, for which no special exception has been filed. Every Roman Catholic, almost all Roman Catholic schools have a private chapel, and a number of Protestant schools do as well. But we accepted that ruling, did not contest it in court, and we came and made a special application for special exception use. In describing the use, we described a number of things that we were trying to assure the city and the community that this was a very modest institution. Incidentally, it is a religious not-for-profit corporation under both the state of Florida and the IRS, and it is governed by a 9-member board of directors, of which 4 members are present tonight. At any rate, it turned out that when the magistrate issued the special exception, he put a whole series of requirements which were my description of how we operated. And he trampled all over the First Amendment to the U.S. Constitution, which forbids government entities from regulating the internal operation of religious entities. He limited us to 4 services a day. He said we could have no outside services, and he prescribed thing after thing after thing that were really internal religious issues. He even limited the attendance at normal daily services at about half what the special exception provided seating for, as rated by the fire marshal. All of those, I think, Mr. Metz will agree, kind of stretched it. Now, we didn't make a big fuss about it, but he also ordered all religious symbols removed from the external part of the property, which tramples on a Florida law as well as the United States Constitution. We were contacted by a major national law firm that fought these kind of battles, and of course they wanted to have a battle on the front steps of the city, which I declined to do because I'm a long-term resident. I chaired the Board of Adjustment in this community for about 14 years, served on it for 17, and I did not want that kind of publicity from Madeira Beach. So we elected to not remove the symbols, have a violation hearing, and present a brief with the constitutional law. And a compromise was reached, and I agreed that we would remove the small dome that was up at that point, but all the other religious symbolism would stay in order for the community furor to go away and to make peace with the community. The dome, incidentally, which is relatively small and is not specifically a church dome, which was designed as a copy of domes on Mediterranean houses in Greece and in Italy, and you see some in the United States. We came back subsequently, several years later, when the community could see that contrary to the word they had put out, that we were going to build a big church and have huge traffic problems and all, that we had very little traffic, very modest activity in the place, and that it was in no way a problem or nuisance for the neighborhood. And we requested again that the dome be allowed. When the magistrate ruled on it, he turned it down, and I was kind of shocked by his ruling because he hadn't done his homework. He said that we should have appealed the first time, and we couldn't because we made a compromise agreement, and that prohibited us from appealing from the board, from the magistrate to the circuit court. The second thing is that he said that the dome itself was a contradiction of the residential nature of the neighborhood, which was not true because it was a copy of a residential type dome. We even offered at that second hearing to install the dome without the cross, just for the sake of peace. Now, I'm here today for a couple of reasons. One is we do need to build an additional closet. We have a small 3.5 by 5 closet, and we're having to store things other places because the Orthodox Church, like the Roman Catholic Church, is a liturgical church. We have 6 seasonal colors that we have to have hangings for all the altars and tables, and vestments for the priest and other servers. We have incense. We have other seasonal items, icons, and candles, and we're simply out of space. And I would like to be able to construct a 7 by 8 closet on the south side of the building. And incidentally, if you would like to pass these out, this shows it is fully within the setback. So we're not asking for any variances in terms of setbacks. Simply a closet with no plumbing, no window. The reason we're asking for the variance, and we would really like to get rid of the square footage requirement, is because this is costing us $300 extra to build a small closet, and a couple of months of posting a petition, going through hearings, and we would like to be able to modify that building as needed in small ways. Now, this in no way allows us to expand the chapel into a large facility, because in the original special exception, which we're not asking to modify, paragraph 1404 limits us to 25 seats in the facility. And we're not asking to change that. We're perfectly content with that. And also 14.06 specifies the number of parking places we have to operate. So in order to create a larger chapel facility, we would have to have those 2 items modified in a subsequent process with the Planning Commission and with the magistrate. So we're not asking for that. So that's the additional request. Really, the issue here is equity under the law. A basic principle that I know from having chaired the Board of Adjustment for 14 years is that you do not deny special exceptions or variances when to deny it would deprive the applicant of privileges enjoyed by other properties in the district. The facts are that Church by the Sea, which is also in an R2 district, does not have a size limitation on their sanctuary. So they can add to it without going through a special process. And so we are in an inequitable or an unfair position. The second thing is that in the neighborhood, our neighbors, if you look at us as a residents, can add to their facilities as long as they're within the proper setbacks in the law without going to the Planning Commission, the Board of Adjustment. And so we feel that we are in an inequitable or unfair position with that we're being discriminated against both by comparison to the church, the other church in the community, and by residents in the neighborhood. I am not asking, although there are a number of other provisions still in place that really represent that the city imposing religious interference with a chapel, and I'm not asking to change those, even though that's probably a constitutional law issue and probably should be reviewed. A number of incidentally those provisions, like the number of services and attendance at services, were changed wisely by the city in order to prevent some kind of serious civil rights case under the Constitution.